This is case 2011-0304 in the matter of Ronald Brownell and Irene Brownell.
May it please the court, I'm Joshua Gordon. I represent Irene Brownell, who was left penniless, destitute, and homeless by Mr. Brownell squandering about $100,000 of the marital estate. Mr. Brownell claims that federal law prevents payment of alimony from VA benefits, and the language that my brother has pointed to is the law bars, quote, claims of creditors, attachment, levy, or seizure. The family court considered the benefit income, but didn't attach it, levy it, or seize it. In Rose v. Rose, United States Supreme Court quoted the congressional record, which created the VA benefits explicitly to pay family obligations, and specifically allows VA benefits to be used for child support.
And you say a majority of state courts has agreed with that?
Yes, they have.
And assuming for the sake of the question that you're correct, shouldn't the trial court have considered backing out the reasonable needs of the payor from in terms of figuring out what an alimony order should be? I'm not sure that that happened here.
In other words, the intent of Congress can't have been to have him incarcerated.
Incarcerated
for contempt.
For contempt.
And penniless.
Well, if the family, I think what you're saying is if the family court ordered, let's say he gets $3,500 a month and it gave in alimony, family court gave the spouse $3,500 a month, so he doesn't have anything left?
Right.
Oh, I suppose that would be a problem for a variety of reasons, but nothing like that happened here. All the cases cited by Mr. Brownell, including Mansell, are from community property states, and they all address whether VA benefits are property for the purposes of property division. But here, the court just considered them regular alimony, and thus, regular income, and thus available for alimony. The court has to consider, moving on, the squandered estate as well. First, there was no preservation of that issue below. New Hampshire statute divides property that, quote, belongs to the parties. Belong means own, not
you know what?
possess.
You know the thing I'm having trouble with, Mr. Gordon, is I understand what you're getting at, but I guess the thing I'm having some difficulty with is if the property no longer exists, isn't whatever the court does, isn't the real remedy for your client going to be that, you know, the court says this estate was worth at the time of the divorce X amount of dollars, your client should get half of that X amount. It no longer exists, so your opponent's client has to pay that amount in some periodic way over time. I mean, right. Isn't that, and so whether you call that dividing the estate or simply imposing a debt, I'm not sure that makes all that much difference.
No, but I don't think so either. But I think the contrary position is the incentives are so perverse. You know, it's like burn down the house when you leave so that the spouse can't get anything. You know, I don't think social policy wants to encourage squandering estate.
Let's get back to the nuts and bolts. Suppose this case is remanded and there's another contempt finding. There's an ability to pay something that is found by the trial judge, and then an ensuing failure to pay. Then Mr. Brownell is incarcerated. Why isn't that the equivalent of a levy, seizure, attachment, or even worse?
Well, first he gets a show cause hearing. So he shows up at a show cause hearing and says, you know, Judge, I can't pay. I only have this much money. And like the scenario you laid out, you know, he gets it on Thursday, the hearing on Friday, what have you.
Right.
But, you know, he does owe the money, and holding in contempt is a possibility of going to jail, but there's no capias issue. So he gets his show cause hearing, and there will be a determination on how much he can pay. I think whether his period for paying it is 30 days as was ordered or 5 years doesn't really matter, except that he has to pay it over some time, maybe supervised by the court or whatever, as long as the court doesn't reach into the federal government and say, you know, and attach that or garnish it and say those checks shall be sent to some other place. Then it's just an ordering of how he's to use his income, and that's normal and standard.
So in other words, your view is that what the federal statute prohibits is getting the money indirectly from the government as opposed to getting it from your client. So once the money's in your client's bank account,
Anything can happen.
with I think the caveat that Justice Hicks points out, you can't leave him not enough money to live.
Yes, there is some self-support reserve with regard to all of these federal benefits, but I don't think we're going anywhere near there. The congressional record that Rose quotes at length is pretty clear on this, that the federal government doesn't want to be used as a collection agency. It doesn't want to be sort of the subject of a USO to tell the checks to go here and there. That's not their business. They just want to send the check to the designee, and that's the end of that. And that's what the purpose of that, that the statute is for. I do want to correct before I sit down. On page 1 of my brief, I said Irene testified about domestic violence. She didn't testify about it. That was an offer of proof. I apologize for the error, but there's no dispute that there was domestic violence in this relationship. The court noted it in its temporary order. There was a protective order issued. The final decree contains a permanent restraining order, and the record suggests that Mr. Brownell was convicted, but I don't think he has been, of assault. Finally, the property award is well within the discretion of the trial court.
Is there an issue with regard to what appears to be a final payment under the trust? In other words, there were payments that were dissipated, but then there's this $15,000 payment that is likely to come, we're not sure, but the court seemed to include that in its calculus of what was owed. And I'm concerned about how we deal with that $15,000 future yet to be received payment from the trust.
Sure. There is no question that some amount is going to be received. It was only the amount that was in question, and the best evidence was that was $15,000.
And we don't have the trust instrument itself, do we?
No, the trust instrument is not in the record, and I think that's a problem for another reason, because whether Goodlander and Temposi applies, which it doesn't, depends upon the discretion that the trustee has. So we don't have the trust document.
But it wasn't clear to me, did the trial court here say wife gets 1/2 of any future payment? I was under the impression the court actually used that $15,000 payment and put that with the prior dissipated amounts and said, and this is what you owe.
I don't think there is a number designated. I think the court said 1/2, but it didn't say 1/2 of what. So I hope I'm not wrong about that.
Okay.
But I think the understanding was, and in the court's findings of fact,
So if
that
the future
matters.
payment is $20,000, she gets half. If it's $6,000, she gets half. That's your understanding.
I think that's right. I think the evidence that everyone accepted was that amount was going to be $15,000, and I don't think there was too much dispute about that. It just hadn't yet been received. Mr. Brownell claims his case, and I want to talk about Goodlander and Temposi. It's not like that, because there the obligee got a percentage, essentially turning the spouse into a co-beneficiary of the trust. And this court said that's not allowed. Here the court carefully avoided that problem by just awarding, making an award, but not creating a percentage. It didn't say you get a percentage of the trust. It says you get a number.
But haven't we said that if all you're talking about is an expectancy, it can't be considered marital property?
Correct. But it's not really an expectancy.
Why not?
Because
How do we know? We don't have the trust instrument.
We don't know. Well, I don't think it's an expectancy, because in Goodlander that was premised on the fact that the trial court said that the spouse could reach in and take a piece of the trust, and it turned on the trust document. Here we don't have the spouse ever touching my client's hands are not on the trust document. My client's hands are only on the money.
So is it clear that if there is never a future payment from the trust, then your client doesn't get any part?
Correct.
of that.
Correct. And which is why at the very end of my brief, I say, you know, even if she gets $47,000 out of $79,000, that's under the sort of $60,000, 60-40 split that I generally think of as the non-fault allowable equitable split in family law cases. Thank you very much.
Thank you. Case submitted, and the court is in recess.